All right, call Toby Weaver.
I've already sworn him in. You may proceed.
May it please the court. Mr. Weaver, can you introduce yourself to the court by stating your full name?
Toby Dean Weaver,
And where do you currently reside?
2034 County Road 1115, Cass County, Atlanta, Texas.
And how are you employed?
I'm a truck driver, self-employed.
Okay. Long haul, short haul, how would you describe it?
Long haul over the road.
Okay. Does that require you to be gone from Cass County for extended periods?
Yes, sir, it does.
Typically, how long are you gone before you return?
I'm usually gone 3 to 4 weeks at a time.
Okay. And then you return home and have how much time off?
Couple days, 3 days at the max.
Okay. And then you're back on the road again?
Yes, sir.
Okay. Mr. Weaver, we were before the court January 19th at a hearing for temporary orders. Do you recall that hearing?
Yes, sir, I do.
And Judge Dowd's orders were signed on February 2nd and thereafter entered, correct?
Yes, sir.
During the, in between the time of the hearing and the entry of the orders, Mrs. Weaver retained Mr. Weems to act as her legal counsel, and on January 25th filed an answer to the original petition, correct?
Yes, sir.
After the hearing, did you go back on the road?
Yes, sir, I did.
And what was your intent relative to returning to the marital residence?
Coming home and her leaving the residence and being able to handle my affairs without the hindrance.
Okay. And you're aware, are you not, that Judge Dowd previously ordered that Jennifer Nadine Weaver and her adult son, Brian Bennington, had until February 28th to vacate the premises, correct?
Yes, sir.
Did that happen?
No, sir.
Okay. Before we go into the violations of the court order, I want to back up a bit. During the period that Mrs. Weaver had legal representation, did I, on your behalf, send written discovery to obtain information from Mrs. Weaver?
Yes, sir, you did.
Okay. And did that discovery become due during the course of time that she had an attorney?
Yes, sir.
And was any information or documents provided?
No, sir.
As a result of that, were we required to file a motion to compel with the court?
Yes, sir, we were.
Additionally, in reference to the prior orders of the court, was Mrs. Weaver required to return certain property to your possession?
Yes, sir.
And did she do that?
No, sir.
Was she also required and enjoined from certain conduct?
Yes, sir.
And was she guilty of one or numerous violations of the court order relative to the temporary injunction?
Numerous.
And all of those are outlined in the motion for enforcement, correct?
Yes, sir.
As a result of her violation of the court order, did you file a motion for enforcement?
Yes, sir.
And were efforts made to set both the motion to compel and the motion for enforcement during the period of time that Mrs. Weaver was represented by counsel?
Yes, sir.
Okay. And were we able to identify a potential date where the court might hear those matters?
Yes, sir.
And as a result of that, did you alter your schedule to make sure you could be back in Cass County for that hearing?
Yes, sir, I did.
Prior to that hearing, did something happen that prevented the hearing from going forward?
Yes, sir, it happened.
And what was your understanding of what happened?
My understanding was that her lawyer had retired or taken medical leave.
Okay. So at the time he took leave, discovery responses were past due and a motion to compel had been filed, correct?
Yes, sir.
And a motion for enforcement had been filed relative to Mrs. Weaver's violations of the court order.
Yes, sir.
Okay. Mr. Weaver, in front of you, I have documents that have previously been provided to both the court and Mrs. Weaver that are identified as petitioners exhibit 1 through 9. You and I went over those this morning, correct?
Yes, sir.
Are you able to identify all of these documents and attest to the court that they are true and correct as to what is depicted therein?
Yes, sir.
And do you feel they would assist you in your testimony and the court in testifying to some matters here today?
Yes, sir, I do.
Your Honor, I'd move to enter petitioners exhibit 1 through 9.
Ms. Weaver, do you have any objection to the court receiving those exhibits?
I don't know what exhibits they are. I haven't received anything.
Buckle up, guys. Today we are stepping straight into a courtroom where everything starts calm but carries an edge you can't ignore. The judge calls the witness, and right away, you can feel this isn't just routine testimony. The tone is formal, controlled, but there's an underlying tension building from the very first words. As Toby Weaver introduces himself, the foundation of the case quietly begins to form. It feels simple on the surface, but you already sense there's a deeper conflict waiting to unfold. This is the kind of opening that pulls you in before you even realize it.
Okay, well, I will allow Mr. Glass to identify each one and then ask you if you have any objections. Go
And
ahead,
Your Honor,
Mr. Glass.
Your Honor, for purposes of the record, these were emailed to the email address that I have for Mrs. Weaver. It's also an email address that she had communicated with me prior to legal representation. And all of these were forwarded to her on Friday so that she would have them in advance of the hearing. Your Honor, petitioner's exhibit number 1 and 2 are copies of com checks that were negotiated by Mrs. Weaver's son, Brian Vindictive. Exhibit number 3 is a Capital One Visa card that was forwarded to the marital residence. Exhibit 4 is a document of deferred payment agreement relative to payday loans that were taken out. Exhibit 5 is a copy of the March 31st, 2021 Red River Federal Credit Union statement. Petitioner's exhibit number 6 is a copy of a GoFundMe account that was set up by Brian Bennington. Exhibit number 7 was a notice that was sent to Bronco Pawn on December the 29th. And exhibit number 8 is a copy of a discovery subpoena that was served on Bronco Pawn. And exhibit number 9 is a text communication between Mr. Weaver and one of the owners of Bronco Pawn.
All right, Ms. Weaver, any objection to the court receiving those documents?
Well, I wish I knew what it was, so I don't know if I should object or not. I don't.
He just described
I
each one.
I understand that, but I have an issue because his client is the one that set up the comm data, and his client's also the one that told me that in the Red River savings account was supposedly for marital support, and he told me to go ahead and get that. So I'm assuming that's what that's about. I don't know.
Okay. I'm going to admit exhibits 1 through 9. May proceed.
Mr. Weaver, relative to exhibits number 1 and number 2, can you describe for the court what these documents represent?
These documents are checks that are served out of my business account. This is how I'm paid through ComCheck. And when you authorize a check, it allows you to withdraw cash from trucking fuel distributors across the country.
And for the court's benefit, Mr. Weaver, if you would, describe how you get paid for your trucking.
I deliver the load. They pay me through ComData, a company called ComData, and they literally take all my pay, and then they either put it on this ComData check, like a savings account through ComData, or now it's direct deposited into a bank account.
Okay. Relative to exhibit number 1, down at the bottom, it notes a process date of February 1 of 2021, correct?
Yes, sir.
And this would have been after we came to court on January 19th for the hearing on temporary orders, correct?
Yes, sir.
And what, if anything, of significance do you note relative to this ComData check that's marked as petitioner's exhibit 1?
One, it has my driver's license number on it, and Brian Bennington's signature.
Okay. After we came to court and you asked the court for relief relative to Mrs. Weaver and her adult son, who y'all had been supporting, did you give Mr. Bennington or Mrs. Weaver authority to go to ComData and take funds out?
No, sir, I did not.
And petitioner's exhibit 1 is a check for $200, correct?
Yes, sir.
If you would go to exhibit number 2, is this a similar check where Brian Bennington has taken money out of your ComData account?
Yes, sir.
Let me ask you this, Mr. Weaver. Is Brian Bennington sophisticated enough, at least based on your experience, to know how to contact ComData and take money out of your account?
No, sir, I do not believe so.
Okay.
All right, guys. Now the story starts taking shape as we learn about Weaver's life on the road. He's gone for weeks at a time, barely home, working non-stop to keep things running. That detail might seem ordinary, but it's actually critical because it explains the imbalance in control over his home and finances. When someone is absent this often, it creates opportunity, and that's exactly what the case is hinting at. You can already see how his lifestyle may have opened the door for everything that follows. It's subtle, but it sets up the entire conflict.
Did that take knowledge of how that process works, who to contact, and what information to provide?
Yes, sir, it would.
Other than yourself, who else would have that type information?
Jennifer Nadine Weaver.
Okay.
Mr. Glass, let me stop you just a moment.
Yes, John.
You have, as I understand it, 2 separate motions before the court. You have a motion to compel answers to discovery, and you also have a motion for contempt. Is that correct? Or a motion
Correct.
for enforcement?
Correct, Your Honor.
Is one of the remedies you're seeking in that motion for contempt incarceration of the respondent?
It is, Your Honor.
Okay. And I'm going to have to go into the question of whether or not she remains able to afford counsel, because I cannot proceed with that. If she's not able, I'll need to appoint her a lawyer. Ms. Weaver, you did have counsel for which you had, I assume that you had retained Mr. Weems at some point in time back in, I believe it was February or March. Is that correct?
It was January after the hearing. Yes, sir.
And I assume also that you're aware that he's recently been allowed by the court to withdraw as your counsel on his own motion, stating that he is, for health reasons, retiring from the practice of law. Were you aware of that?
Yes, sir.
Okay.
Could I address something about the contempt of not leaving the house? It was under his.
No, we're not going to get into that
Okay.
right now. I'm trying to find out if I should appoint you an attorney. What's your current financial situation?
I don't have any finances.
Do you have any income of any type?
Just my son's working.
Your son's working. Do you have any income
No,
yourself?
sir.
How
No,
are
sir.
you?
I'm still pending disability.
How were you able to hire Mr. Weems in the first place?
Well, with help from friends and payment arrangement.
Okay. Are you currently financially able to hire an attorney?
I am not.
Do you have any income source at this time of any type, or anyone that can help you hire an attorney?
I do not.
Do you understand that one of the types of relief that Mr. Glass is asking for, and that the court could, if the court finds you violated the court's orders, grant, is to place you in jail for a period up to 6 months? Do you understand that?
I do now. I didn't understand it. I don't, like I said, I don't know anything about how this works. I was just going under the advice of my attorney.
Okay.
Your Honor, the remedies that we seek through enforcement is outlined in the motion for enforcement that was filed while she had legal counsel.
I understand, but I think the fact that she had counsel at the time is not going to help the court very much when it comes to the fact that she doesn't currently have counsel. Because the question is whether or not she is presently indigent, unable to afford counsel if incarceration is sought as a remedy, which apparently it is. Well, not apparently it is because you've told the court that.
And Your Honor, that is in part why we produced exhibit number 6, showing that her and her son have set up a GoFundMe page
Right.
to help her with her financial or her legal endeavors.
Okay.
All right, here's where things take a serious turn as the court order comes into focus. The judge had already ruled that his wife needed to vacate the home by a specific date, and yet, that order was simply ignored. That's not just a misunderstanding, that's direct defiance of the court. When Weaver confirms she never left, the tension immediately spikes. This isn't just a domestic disagreement anymore, it's a legal violation. You can feel the shift from background context to real conflict. From this moment forward, the stakes are no longer personal, they're judicial.
That GoFundMe is no longer up. It was taken down very early on in this. And the $120 was given back to the donors.
Well, I'm going to go ahead and appoint her a lawyer, Mr. Glass, for the contempt action. I'm going to appoint Clint Allen as her attorney. And I'll set off the enforcement action until such time as Mr. Allen can be notified and come up to speed on the case. Now, as far as the motion to compel, are you also asking for incarceration as a remedy in connection with that motion?
No, Your Honor.
Okay, then I'll proceed with a motion to compel today then. So,
Your Honor, relative to the enforcement, my client has and will continue to incur harm due to her refusal to leave the residence. We have no other remedy from the court than to ask for writ of attachment to physically remove her. Otherwise, he's displaced indefinitely. She was required to vacate the home under this court's order over a month ago, and her and her son are still living there.
Your Honor, can I speak?
yes,
If you'll give me to the end of the week, I'll be happy to leave. I was under the advice of my attorney at the time, but I will be happy to leave the home if you'll just give me to the end of the week to get my things.
you talking about this Friday?
Yes, sir.
All right. Well, I'll conditionally grant the writ of attachment, Mr. Glass. If she's not out by 5 o'clock this Friday, then I will sign the writ of attachment or order for the writ.
And Your Honor, can the court reiterate its prior orders that she can't take anything other than her personal belongings out of the home? I don't want the home pillaged when Mr. Weaver gets back in it.
Absolutely. Ms. Weaver, you need to, since you're now representing yourself, at least until you have a chance to meet with Mr. Allen, you need to go back over that court order that I signed some time ago. Do you still have a copy of it?
I do. I'm not going to pillage the home. I'm just going to remove my personal items.
You need to read over it and make sure you're in compliance, because your failure to comply is punishable by contempt and confinement in jail.
Yes, sir.
You understand?
Yes, sir.
Okay. Do you know Mr. Allen where his office is?
I do not, but I'll find out.
It's in Atlanta,
Okay.
downtown.
Your Honor,
Yes.
if I may, as indicated in Mr. Weaver's testimony, this is the second time he's had to leave his job, come in during a pending bankruptcy to try to get Mrs. Weaver's cooperation. I was able to confer with him while you were speaking with Mrs. Weaver, and so that we don't further prolong this, he would like to go forward with the enforcement with the understanding that we cannot seek incarceration at this point.
Okay, well, that's acceptable to the court.
Okay.
I can go forward with it as long as there's no incarceration being sought. So you may proceed with that.
Thank you, Your Honor. Mr. Weaver, relative to petitioner's exhibit number 2, this is another $140 check that was negotiated by Mr. Bennington, correct?
Yes, sir.
Without your consent?
Yes, sir.
And again, the same process would have had to have been employed for him to take money out of your account.
Yes, sir.
Were you able to discover additional efforts to liquidate money from the COM data that is not represented in petitioner's exhibits 1 and 2?
Yes, sir. There was another $100 check that was never cashed, so they returned it after 60 days.
Okay. Meaning it was negotiated, or meaning it was written, but whoever received it didn't cash it?
It was authorized to be cashed out, but they never took it anywhere to cash it.
Do you know who authorized that?
It was authorized through Jennifer Weaver or Brian Bennington.
Okay.
By telephone.
Relative to exhibit number 3, did you recently order a Credit One credit card?
No, sir, I did not.
Okay. Did you receive this in the mail?
Yes, sir, I did.
And who, it notes in the top left-hand corner that one card was ordered, correct?
Yes, sir.
And it was sent to the address that Mrs. Weaver has occupied and refused to vacate, correct?
Yes, sir.
And it was actually a credit card that was sent to you.
Yes, sir, it was.
Did you authorize any application to get a credit card in your name either before or after we went to court on the hearing on temporary orders?
No, sir, I have not.
Now the situation escalates fast, and it becomes clear this isn't just one issue, it's a pattern. Discovery requests were ignored, documents weren't provided, and legal motions had to be filed just to force cooperation. That's a big deal in court because it signals resistance to the process itself. On top of that, multiple violations of the court's orders are confirmed. This paints a picture of ongoing noncompliance rather than a one-time mistake. At this point, the case starts leaning heavily in one direction, and you can feel the pressure building with every unanswered obligation.
Relative to exhibit number 4, these are payday loans, a delinquency notice that was sent to you, correct?
Yes, sir.
Have you taken out any payday loans?
No, sir, I have not.
Did you make inquiry to determine if this was one loan or multiple loans?
Yes, sir, I did. And it turned out to be multiple loans.
Okay. And again, it's to your name at your address, correct?
Yes, sir.
Did you authorize or consent to any of these loans being taken out?
No, sir, I have not.
Did you also make any discovery that we didn't talk about at the last hearing relative to Western Union transactions?
Yes, sir, I have.
Okay. And what, if any, discovery did you make relative to Western Union transactions?
I found that over the period of 2019, there was $11,885.81 sent Western Union transaction to some more.
Okay. And this is over and above all the monies that we talked about at the last hearing that were liquidated from accounts without your knowledge or consent?
Yes, sir, it was.
Okay. Relative to exhibit number 5, can you tell the court the significance of this Red River Federal Credit Union statement?
This statement shows the amount that is paid by my trustee, bankruptcy trustee, to the account attached to the loan.
Okay. In the upper right-hand corner, this shows to be a statement ending March 31st of 2021, correct?
Yes, sir.
And the name on the account is your name only, correct?
Yes, sir.
Will you explain to the court how Red River works relative to the checking and savings accounts?
Red River works as a savings account is through the primary, the checking account. If you have someone signed on with you or as a signature can use the checking account. And Red River had me lock down the checking side of it, but I had to leave the savings side open for the bankruptcy.
Okay. So as part of your bankruptcy, you had to leave the savings account open.
Yes, sir.
Is Mrs. Weaver's name attached to that savings account?
No, sir, it's not.
Okay. Did you become aware relative to money being taken out of that savings account by Mrs. Weaver?
Yes, sir, I was.
How did you become aware?
We became aware of it when the bankruptcy lawyer and the bankruptcy trustee was asking for the accountability of the payment that I do not have any way of, or not supposed to use it because that is strictly deposited for bankruptcy purposes.
Okay. So meaning money goes into this account and then the trustee uses that money to satisfy obligations in your bankruptcy.
Yes, sir.
Mrs. Weaver took money out of that account. And so the bankruptcy trustee comes to you and says, where's the money?
Yes, sir.
Okay. Would you ask for orders of the court that Mrs. Weaver do anything that she needs to do to contact Red River and remove her name from that account so that that doesn't happen in the future?
Yes, sir.
Relative to petitioner's exhibit number 6, did you become aware of a GoFundMe account set up for Mrs. Weaver?
Yes, I did.
Okay. And is exhibit 6 copies that were taken online of this GoFundMe account?
Yes, sir.
Okay. It notes on page 1 that it was set up by Brian Bennington, correct?
Yes, sir.
And that's Mrs. Weaver's adult son who lives in the home with her.
Yes, sir.
It notes that her husband completely abandoned her. Is that true?
No, sir.
It notes that her husband took everything out of every account. Is that true?
No, sir.
It notes that her husband left her with no vehicle. Is that true?
No, sir.
All right, just when things are moving forward, the entire process hits an unexpected twist. The scheduled hearing can't even proceed because her attorney suddenly steps away due to medical reasons. That changes everything in an instant. Legal momentum stalls, and what should have been a decisive moment turns into another delay. In cases like this, timing is crucial, and any interruption can shift the balance. You can sense the frustration here, especially for Weaver, who adjusted his entire schedule to be present. It's a reminder that even the legal system can be unpredictable.
On the second page, it notes in the upper left-hand corner that you're supporting helping a mother in desperate need. Your donation will benefit Brian Bennington. Do you see that?
Yes, sir, I did.
And then on page 1, it notes that at this point in time, there was an anonymous donor and a G Heart Care giver for a total of $120.
Yes, sir.
Do you feel that this was another effort to defraud people of money?
Yes, sir, I did.
Relative to the mail that has been forwarded to the marital residence since the last hearing, how many pieces of mail have you actually received?
Since January, I've only received 4 pieces of mail.
Is that unusual?
Yes, it is. Usually every mail delivery, I have 5 to 6 pieces in there daily.
Okay. And you're aware, are you not, that under the prior orders of the court, parties couldn't tamper with stuff, divert mail, do those sorts of things?
Yes, sir, I was.
Do you feel that that's happened dozens of times since we were in court last time?
Yes, sir, I do.
Have there been instances where you have found that your email account has either been hacked or email has been sent out from someone purporting to be you to other people?
Yes, sir, I have,
Has that happened on one or numerous occasions?
on numerous occasions.
Have you been able to stop that?
Yes, sir, I have.
Who would have known your account numbers such that they could have got onto your account and sent out fraudulent email?
Jennifer Weaver.
Anybody else?
Probably her son, Brian.
Okay. With her assistance?
Yes, sir.
Have there been occasions since the last hearing where you have been told things about hard drives on computers by Mrs. Weaver?
Yes, sir, there has.
And what has she told you?
She told me that they were contained child pornography, underage pornography, and that if I wanted them back, I'd have to go to Atlanta Police Department to receive them.
Okay. And did you in fact go to Atlanta Police Department?
Yes, sir, I did. 30 minutes later.
Okay. And did they have copies of your hard drives?
No, sir, they did not.
If you will, for the court's benefit, describe these hard drives and what might be on them.
These hard drives are roughly half the size of this sheet of paper. They're a terabyte each. They have TM manuals on them when I work for the government, which is all the tech manuals. They also have my pictures that I took over there while I was overseas, and they have music on them, downloadable music.
Okay. Would you ask the court to enter orders that these hard drives be returned to your care and custody?
Yes, sir, I would.
You heard, did you not, Mr. Weaver, my discussions with Judge Dowd earlier relative to the pawn shop?
Yes, sir, I did.
You're aware, are you not, of efforts that were undertaken by me to issue a discovery subpoena to obtain records?
Yes, sir.
Okay. And did the pawn shop give us the records that we requested?
No, sir, not all of them.
Okay. Relative to the records that they did provide, were you able to discover information relative to property that was pawned by Mr. Bennington and Mrs. Weaver?
Yes, sir, I was.
Did you also have subsequent discussions with the pawn shop owner relative to her interactions with Mr. Bennington and Mrs. Weaver?
Yes, sir, I did.
And did Mrs. Runnels make any comments to you relative to whether this was only Brian Bennington or it was he and Mrs. Weaver?
Yes, she did.
What did she tell you?
She told me that on numerous occasions and most of the time, both of them were there.
Okay. And that would include the pawning of several guns.
Yes, sir.
Do you recall what Mrs. Weaver testified to under oath at the last hearing as to her knowledge of any guns being pawned?
Yes, sir, I do.
And what did she tell Judge Dowd at the last hearing?
She told Judge Dowd that she specifically had no knowledge of any guns.
Okay. And were you able to determine whether or not the pawn shop still had any of your guns after we were in court last time?
Yes, sir, I did.
Okay. And were, to your knowledge, were any efforts undertaken by Mrs. Weaver to get those guns back to you?
No, sir.
And you're aware that the prior order specifically told Mrs. Weaver to secure and return any personal property items that had been removed from the home, to include all guns and weapons?
Yes, sir.
Were you able to eventually talk with the pawn shop and pin down one gun that they had in their custody last month?
Yes, sir, I was.
And what gun was that?
That was the Model 58 Smith & Wesson 38 Special.
Now, was that a gun that you bought during your marriage to Mrs. Weaver?
No, sir, it was not.
Okay. That would have been your separate property.
Yes, sir.
Okay. And did the pawn shop turn over that gun to you?
No, sir, they did not.
What, if anything, were you told relative to how you could get that gun back?
I was told that they had found it and that I could buy it back for what they had in it.
And what was that?
I was under the impression that it was $80 pawn, and they proceeded to try to sell it back to me for $300.
Now we step into a critical phase where evidence is introduced. and things start getting uncomfortable. Multiple exhibits are laid out, financial records, transactions, even a GoFundMe account, but instead of engaging with the details, she claims she hasn't seen any of it. That response immediately raises questions. The attorney insists everything was sent, while she pushes back with uncertainty. This creates a direct clash in credibility, and in a courtroom, that's everything. You can feel the judge weighing both sides carefully. It's no longer just about evidence, it's about who the court believes.
The vehicle that Judge Dowd temporarily awarded to Mrs. Weaver, and let me ask you this. To your knowledge, does Mrs. Weaver currently have a valid Texas driver's license?
No, sir, she does not.
Okay. The truck that was awarded to her, is it your name's on that vehicle?
Yes, sir.
Is the vehicle insured?
Yes, sir, it is.
Okay. In light of the fact that if she operates it, she would be operating a motor vehicle in the state of Texas without a license, would you ask the court to allow you to remove that from your insurance in order that she provide coverage?
Yes, sir.
Do you feel that those steps would be necessary to protect you in light of the fact that the court temporarily awarded the vehicle to her if it's wrecked or if someone's harmed relative to that vehicle?
Yes, sir.
You don't want your name associated with it. Would
No,
that be
sir.
fair?
No, sir, I do not.
Is her son also, are you paying for his insurance on that vehicle?
Yes, sir, I am.
Okay. You understand that the court's orders, you have to seek permission of the court before you do these things.
Yes, sir, I do.
And would you ask permission of the court to remove both Mrs. Weaver and Mr. Bennington from insurance on that vehicle in order that if she gets a valid driver's license and if she's going to drive it, that she be ordered to provide insurance?
Yes, sir.
Mr. Weaver, since we went to court the last time, would it be safe to say there's been numerous occasions when you've had to notify me of things that weren't being done pursuant to Judge Dowd's orders?
Yes, sir.
In addition to the relief you're asking today, have you gone to the Cass County Sheriff's Department?
Yes, sir, I have numerous times.
Okay. Have they been able to assist you with anything?
Not very much.
Okay. Did they indicate that they would look into any particular aspect that we've talked about today?
Yes, they did.
And what was that?
The illegal use of the com data and my guns and the hard drives.
Okay. Have you been told that they will take care of all of that, or this is civil matters for Judge Dowd to deal with?
They have, on all three occasions, said this is a civil matter.
Okay. Have you gone to the Cass County District Attorney's Office trying to get assistance?
Yes.
Okay. And have they indicated they will pursue things, or have they indicated this is a civil matter to be dealt with in the divorce?
They have indicated that this is a civil matter to be dealt with in the divorce.
Mr. Weaver, how do you feel right now knowing that we went to court and Judge Dowd issued all of these orders and Mrs. Weaver's not complied with anything?
A little upset.
Okay. Do you feel helpless?
Yes, sir, I do.
Do you feel that the Sheriff's Department or the DA's office is going to jump in and stop this?
No, sir, I haven't felt that.
Okay. Is it difficult to be a long haul truck driver and take care of business so that you can pay your obligations in bankruptcy and deal with all of this on top of that?
Yes, sir, it is.
Mr. Weaver, what are you asking of Judge Dowd today?
I'm asking again that the court step in and help me rectify the situation to where I can proceed with my other obligations in the bankruptcy and be able to have my funds and take care of my business.
Basically the same thing we asked back in January.
Yes, sir.
All right, this is where the case hits a major turning point, and the tension spikes sharply. Evidence shows money being withdrawn from Weaver's account without his permission, and the details are hard to ignore. Checks were issued, signatures appear, and the process required insider knowledge. That's what makes this so serious. It wasn't random or accidental. When Weaver makes it clear he never authorized any of it, the implication becomes unavoidable. This is no longer just about disobedience of court orders, it's about potential financial misconduct. The entire narrative shifts right here.
Do you have any level of confidence that Mrs. Weaver is going to do anything she says she's going to do?
No, sir, I do not.
You see any reason why it's going to take her until the end of the week to get out of the house?
Yes, sir, I do, because she hasn't planned in the last 2 months to even move.
Okay, so despite the fact that Judge Dowd said on January 19th, I'm going to give you until February 28th to vacate the house, it's your understanding she's made no efforts to plan to vacate?
No, sir.
Okay. Would you ask that she be given 48 hours to get out of the house
Yes, sir.
and take her son with her?
Yes, sir.
And if not, that Wednesday at 5 o'clock, if she's not out, that the court issue a writ of attachment and have the sheriff's department physically remove both Mrs. Weaver and Mr. Bennington from the house?
Yes, sir.
Okay. Do you feel that if she's given another week or another month that you could incur additional damage?
Yes, sir, I do.
Are you asking that through the motion for enforcement by contempt and the motion to compel that you receive an award of your attorney's fees and costs that you've incurred?
Yes, sir.
Are you asking that she be ordered to turn over the hard drive?
Yes, sir.
Are you asking that she be ordered to insure the vehicle that's in her temporary care and custody if she's going to use it?
Yes, sir.
Would you ask that she leave all property in the marital home other than her personal hygiene items?
Yes, sir.
Are you asking that the order dictate that she is to do anything she needs to do to make sure that her name is removed from any accounts that you have access to, such that she cannot continue to deplete funds from any account?
Yes, sir, I do.
Do you have concern that despite whatever is ordered today, we're going to be back before the court seeking other relief?
Yes, sir, I do.
Okay. Relative to the items at the pawn shop, were you able to go through the documents that were provided by Mrs. Reynolds?
Yes, sir, I was.
And we were able to work our way through these documents, correct?
Yes, sir.
And there are documents listed such as power washer, lawn and garden equipment, Troy Built Professional Series, impact wrenches, Craftsman drive sets. All those items, were they yours?
Yes, sir, they were.
Were some of those items separate property, or was all of that bought during the marriage?
That was separate property that I had prior to marriage.
Okay. And you're aware that those items were pawned, correct?
Yes, sir.
There were also items such as a weed eater, a Cub Cadet, looks like a straight shaft. Was that an item that you owned prior to the marriage or bought during the marriage?
Bought during the marriage.
You're aware that it was pawned as well, correct?
Yes, sir.
Air compressors, air hoses, did you own those prior to the marriage or purchased during?
Purchased during.
Okay. You're aware those were also pawned, correct?
Yes, sir.
Were those pawned without your knowledge and consent?
Yes, sir, they were.
Did you benefit in any manner from any of the funds received from the pawning of those items that were bought during the marriage?
No, sir, I did not.
Makita drills, Tundra inverter, were those your items of separate property or community?
The Tundra was mine and the Makita was his, was Brian Bennington's.
And did you also become aware of numerous firearms that were pawned?
Yes, sir, I did.
Were you able to come up with a listing of the guns that were community property, meaning purchased during the marriage versus separate property?
Yes, sir, I was able.
Okay. And can you tell the court how many guns that you owned that were taken that were your separate property?
There was 4 of them.
Okay. Were you able to locate any of those as being pawned at Bronco Pawn and Gun?
Yes, sir. I was able to locate that they all were pawned at one time.
Okay. Meaning that at one time they were all pawned and then redeemed.
Yes, sir.
Okay. And then what is the current disposition of those guns?
Unknown, except for one of them.
And was that the one you testified to earlier, the
Yes, sir.
Smith & Wesson?
All right, guys, this is the moment where everything comes to a head and the consequences become real. The judge brings up the possibility of jail time, and suddenly the tone changes completely. She admits she doesn't even understand how serious things are, claiming she has no financial means for a lawyer. The court steps in and appoints one, but the pressure doesn't ease. Then comes the final directive: leave the house by Friday or face forced removal. On top of that, more financial concerns surface, including a credit card issued without consent. This is where the case transforms from tension into accountability, and the outcome starts closing in.